This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
My lord, only one thing before I start, my lord. In this appeal, my lord, there is two appeals where they are initially added. Thereafter, they are at the state and the commission who oppose us before the single bench, both on the maintainability and they heard also on merit. My lord, since we are the writ petitioners, my lord, let the state only because after all if I proceed with my submissions, my lord. Thereafter, state and commission again say these points because they oppose us.
It will never come. We have to.
My lord,
we
they
will
are
hear.
here, my lord. They are here.
No, that is commission. The Advocate General has to be heard.
Advocate General was also.
So who is for the state. Now adjournment will be taken. My Advocate General. Huh?
The learned AG is online.
Where is he? Yes. Yes, Mr. Dotto.
That is. One.
And this is the difficulty. And secondly, my lord, on the very
Now,
first
what
day,
is the difficulty that if states how will you be benefited?
not benefited, my lord, since they are arguing against in supporting the appellants, my lord, because they argued in support of the applicants, my lord, before the learned single judge, my lord. Again, my lord, before the appellant here, after all.
You argue, what is your point? You argue now. We will hear the argument. Yes.
My lord, thereafter, again, we have to give reply to their argument.
But why? There is no respondent will not have to give any reply.
My lord, then if the respondents do not argue on maintainability,
Then we can never finish this matter.
my lord, another thing, my lord, I must point out before your lordship, on the very first day I submitted, since this matter is being fixed, my lord, it was made to understand, my lord, maybe it was my fault, my lord, that Mr. Lanet Senior, Mr. Sengupta and Mr. Korvila, because since I am being led by Mr. Bhattacharya, I submitted on the first occasion also Mr. Bhattacharya was present.
No, we have heard them. You please tell us what.
My lord, we filed this writ petition, my lord, in 2022, and the selection was, appointments were made in 2018, panel expired in 2019.
You filed the writ petition in
2022. But appointments were made in 2018, 2019 and panel expired in 2019 December. Admittedly, commission in its affidavit has stated so. So, my lord, once panel has...
It expired when?
December 2019, my lord. The date, my lord, I am supplying to your lordship.
Yes.
December 2019. Thereafter, my lord, suddenly your lordship remembers a matter when your lordship was sitting in the division bench, a matter came up before your lordship against, my lord, this creation of against creation of supernumerary post. My lord, when these 9-10 SLST matters were going on, my lord, during these matters were going on in 2022, that is in May 2022, my lord, the state framed this, took a cabinet decision and my lord passed the order of 19th May, that is creation of supernumerary post. My lord, it was pointed before the learned single judge.
19th May
2022.
This is the memo of creation.
My lord, that was challenged before the single bench, which bench was hearing the SLST that 9, 10, 11, 12 matters. My lord, on seeing that, my lord, and a affidavit of the commission was placed also before that bench to accommodate illegal appointments, supernumerary post has been created. This is on record and application of the School Service Commission. My lord, seeing that, the learned single judge stayed the operation of that 19th May and directed the secretary of the school education department to come up with the file as to what prompted this creation of supernumerary post. And my lord, the learned single judge...
separate writ petition.
My lord?
Is in a separate writ petition.
No, my lord.
Yes.
My lord.
No. These are in connection with...
No, my lord. I tell your lordship why. The memo is a single memo of 19th May, including 9, 10, 11, 12, physical education and work education.
Memo is a, yes.
My lord, what happened thereafter? The single bench said that this memo cannot be given effect to and directed the secretary to be present personally with all the files. My lord, an appeal was preferred before your lordship in a division bench, my lord, by the state as well as the commission. Your lordship upheld the order of the single bench. My lord, against that, your lordship in the initially was talking about that Sandeep Prasad SLP. Against your lordship's order passed in Sandeep Prasad that the supernumerary post, the secretary should
That Sandeep Prasad was included in the bunch of matters which
He-
were taken by the single judge.
my lord,
Prasad,
it is thereafter. I am coming.
on the Prasad matter.
Yes. Sandeep Prasad appeal was against your lordship's order. That is a separate appeal which was filed by the state and the commission. And my lord, this Boishaki Bhattacharya matter which was heard by the division bench, that was on the legality of the appointments of 9, 10, 11, 12, that was separate, and that Sandeep Prasad appeal, my lord, before the Supreme Court was regard to the your lordship's order that supernumerary post for creation of
But our
accountants
order
illegal
was set
appointments.
aside.
My lord, no. That was, my lord, taken up together. All those appeals, my lord, were taken up together
Before the Supreme Court.
before the Supreme Court. The Supreme Court initially first, my lord, by on 3rd April's order, set aside all the appointments. Thereafter, my lord, on 8th of April, on the issue of the division bench directed that there shall be an investigation to be conducted by the CBI. Why? As to against those person against the cabinet which took the decision of creating supernumerary post. My lord, there the Supreme Court said no investigation can be carried on against the persons of against the cabinet rather who have directed for creating the supernumerary post. But my lord, the whether the creation, whether the state can at all create the supernumerary post was kept open. My lord, now in why I came up in 2022, immediately on 19th
No, then our judgment
was
upholding
affirmed.
the single
Was
benches
affirmed.
was affirmed.
Was affirmed. My lord, my lord, thereafter what happened?
Direction for CBI inquiry.
No, my lord. Which appeal?
That
Sandeep
That
Prasad.
we delivered the judgment.
Yes, my lord. Your lordship upheld the judgment that there should be a CBI investigation, and the secretary of the school education department was to appear personally before the single bench.
Then what happened?
My lord, initially the Supreme Court stayed that appearance.
Stayed our order.
No, stayed the appearance of the secretary of the school education department.
But the order was not touched.
Order
Then
was
what
not
happened?
touched. Ultimately, my lord, the Supreme Court in Boishaki Bhattacharya directed that CBI will not investigate against the cabinet who took the decision.
For creation of
Supernumerary post. But the order creating the supernumerary post, whether state can has
So or
state,
not.
state has the power, my lord, was not interfered. It was kept open for the single bench to decide. Now,
Single bench means before who?
my lord, this matter was pending from 2022. Challenging this 19th May order, my lord. After this 19th May order was passed, we the writ petitioners, my lord, approached this honorable court saying that we participated, we were not given the Weimar sheets, and there are this, and
Have you stated all these things in your writ petition?
every,
Give us the paragraph numbers of your writ petition.
my lord, the writ petition.
So Supreme Court took note of the pendency of the present petition.
My lord, that was in when we initially filed the writ petition, there was no Supreme Court pending. After filing of the writ petition, my lord, this Boishaki Bhattacharya and everything happened.
We are concerned with the Sandeep Prasad.
My lord, Sandeep
In
Prasad,
Sandeep Prasad decision, you stated that whether cabinet can take decision, that would be decided by the.
no, that was decided in Boishaki Supra, Boishaki Bhattacharya. Because ultimately, my lord, the division bench, while deciding Boishaki Bhattacharya, also directed the cabinet, the CBI should investigate as to how the cabinet decided to accommodate illegal appointments by creating supernumerary posts. This in Boishaki Bhattacharya, our division bench decided that, directed investigation. So, my lord, it went before the Supreme Court, state and everybody filed. Supreme Court decided the CBI will not look into the cabinet. The validity of the supernumerary memo was kept open.
Okay. Now you just regarding locus standard.
Yes.
Now, as per the Mr. Sengupta's submission, that one person can file a petition who is aggrieved. That means who has suffered injury by the action or inaction of any administrative authority or executive. Now, Mr. Sengupta has gone a little bit further. He has said that who can get benefit if this order of creation of supernumerary posts is set aside, whether you will get benefit. So on one hand, you didn't suffer, according to Mr. Sengupta, you didn't suffer any injury. So according to him, you cannot be treated as a person aggrieved. And on one hand, even this order is set aside, you will not get any benefit.
Yes,
what is your answer to this?
My lord, your lordship knows maintainability is one thing and entertainability is another thing. My lord, what I have learned from your lordships and your lordships.
You have brought that judgment.
My lord, this is has also been decided in Boishaki Supra by our division bench. It is, I don't know whether it is.
Yes, that is there.
That is there, my lord. I will place that, my lord. Why I am doing so, my lord? Rejection of plaintiff, if I take from the clue of Order 7, Rule 11, there are certain grounds on which a plaintiff can be rejected. My lord. On those grounds, any of those grounds, my lord, are not there. On facts, if I have understood correctly, Mr. Sengupta is stating on facts, I am unsuccessful. I am not going to get any benefit. For that, my lord, it requires the court, my lord, to go into the merits of the case. Then only the court can come to a conclusion that whether I am unsuccessful or not, whether I will gain some benefit or not. From, my lord, and for that reason, my lord, a petition may be maintainable. But ultimately, it is found that I am not entitled to the relief. But for being not maintainable, Order 7, Rule 11, those grounds are to be said that it is not maintainable on those points, my lord, under Order 7, Rule 11. It is not the case. If, my lord, the pleadings are whatever pleadings have taken out in the writ petition, my lord, for holding that a writ is not maintainable, even if it is taken that my writ, all the pleadings are taken to be gospel truth, my lord, and they are right. Even if those things, a petition is not maintainable in law, that is not the case. My lord, that has been decided by the impugned order, that if the allegations that have been made in the writ petition,
Which paragraph?
my lord, in the impugned order,
taken to be true at their face value.
then, my lord, the point of the writ petition has to be entertained for deciding with the correctness of the pleading.
All right. What is your next point?
My lord, this is my first point. Second, my lord,
Whether you can challenge the cabinet decision.
my lord, then it is on the merit, my lord. Then I have to, my lord, whether what advantage I have gained.
What is your explanation to paragraph 15 and 17?
Division bench has said you have not challenged.
You have not.
Because the division bench.
However, the essential question required to be decided is at whose stand the said challenge is thrown.
My lord, why the appeal was preferred before the division bench, that has to be seen first. My lord, an interim order was given in 2022, which was subsisting. My lord, suddenly, since the matter was adjourned by the single bench on the ground that it was pending before the Supreme Court, and in the Supreme Court order, my lord, presently, my lord, on 7th May 2025, it is being recorded in the Supreme Court order that it is the submission of the statement. Presently, I don't have that order. state submitted before the Supreme Court that we are not going to give any appointment to in the supernumerary post, naming our writ petition number, that the writ petition is pending before the single bench and there is a stay. So we are not going to give any appointment. So kindly stay the order of CBI investigation. That was the specific submission of the state. Considering that submission that it is state,
In which matter?
my lord, in Boishaki matter, this writ petition was referred.
Between that decision.
Now, then Boishaki matter, that judgment has been finally decided.
No, my lord, before it was finally decided, on
3rd of April 2025.
yes, that was finally decided. Before that, on 7th of May 2025, when the Honorable Supreme Court took up Boishaki's matter for passing any interim order or not, it was submitted by the
It
state.
was disposed of in April, I suppose.
My lord, April 23rd of 7th of May, my lord, 2024.
I see, I
7th
see.
of May 2024.
Huh.
It was taken up by the Honorable Supreme Court, my lord, for deciding the interim order whether CBI will continue with the investigation of the cabinet against the cabinet. My lord, when that matter was taken up, it was submitted by the state that a matter challenging the cabinet decision, that is our writ petition, my lord, is
Now,
pending.
why did that point arise that Supreme Court was asked that action be taken against the cabinet?
Yes,
This was not the subject matter in Boishaki.
yes, that was also the subject matter in Boishaki.
That was also the subject
Yes,
matter.
it was decided by the division bench in Boishaki Bhattacharya, my lord, that this creation of supernumerary posts is absolutely
But that is pertaining to 9, 10 and
Yes, that is
post,
pertaining
not pertaining to this.
but the memo is same, my lord, but it was considered only in respect of 9, 10, 11. And
Achha,
see,
in course of hearing, the state submitted that we are not going to appoint any
give any
person.
appointment, and the matter challenging the validity of the that memo is pending before the High Court.
So very good. Now ultimately,
Yes, my lord, ultimately
Boishaki,
what happened? Ultimately, when the single bench was hearing this matter, my lord,
Boishaki ended.
Boishaki ended, and this matter was being heard by the single bench. My
Yes.
lord, while hearing the single bench matter, we found
Now you said that that issue may be considered by the High Court. That is which is
yes,
that is which order? Say April, May.
No, my lord, final order. That Boishaki final order.
In Boishaki final order, it was said that CBI will continue with
No,
the.
CBI will not continue. CBI investigation was set aside. CBI cannot investigate the decision taken by the cabinet.
To create
8th April order.
supernumerary post.
My lord, what happened during hearing of the matter before the single bench, this matter, my lord, I pointed out that, my lord, the interim order has expired. Kindly extend the interim order. My lord, a point was taken by Mr. Sengupta and the other respondents that an interim order is initially subsisting, it has expired, so it cannot be extended. My lord, I filed an application for extension of interim order. That extension of interim order was heard out, and my lord decided that since the matter was here and it should be extended till the disposal of the writ petition. From that order, my lord, the appeal, my lord, that paragraph 15-16, that appeal was preferred.
Paragraph 15-16
Of my lord, which your lordship was referring, of Justice Showmenshen's division.
Oh, I see.
From that order,
That order means a reinstatement of interim order.
extension of interim,
Very good. It was reinstated and extended.
reinstated and extended, challenging that, my lord,
He went to Justice Sen.
they went to Justice Sen.
Achha.
My lord, what was, and before Justice Sen, my lord, they argued not only that it cannot be extended, they argued that supernumerary is valid, they argued the maintainability, everything. What the division bench, my respectful submission on going through the, my lord, division bench order, my respectful understanding is, my lord, the division bench said, since these persons are awaiting, let the entire issue, my lord, means
No, not the end. Said issue.
said issue, my lord, said has to be decided, my lord, on the basis of the foregoing paragraphs.
Now, where from do you say? We say said issue means which is included in this paragraph.
Not only included
Say
in,
we have left this point to be decided. Said issue.
My lord, said issue means the issue which has been decided in the earlier paragraphs, the issue which has been dealt with in the earlier paragraphs refers to the said issue, my lord.
Said issues, not said issue, not issues.
Yes, said issue. The issue is,
Then
the
the
writ petition is the issue.
connotation ought to have been said issues as argued.
My lord, said issue. What is the issue argued, my lord? The issue argued.
Maintainability.
No, my lord, not only maintainability. My lord, may I go through,
No, we have read it.
Order?
No, maintainability. Huh?
কাছে কাম হচ্ছে না।
Hmm. Acha, any other point you want to address? That your point is that these issues were,
inextricably bound.
these arguments were made, these were, those
Question of
issues
fact.
were left to be decided. Yes, what is
My
your
lord,
next argument?
What? How am I prejudiced by this? Because it is maintained. How am I aggrieved? And what benefit I have got?
Hmm.
My lord, the School Service Commission rules 2016 for appointment of physical education, work education, there is a separate rule. My lord, rule 8 of that rule specifically stipulates the vacancies and the manner of calling the candidates for interview. Whoever participates, my lord, will not be called for interview. My lord, there is a process. Since this work education and physical education, there is no giving TET is not required. So, my lord, suppose the rule says, suppose there are 100 vacancies, then, my lord, 140
In
candidates.
physical work education, no TET is required.
My lord,
In physical education, work
No
education,
TET.
no TET
no
required.
TET.
Huh.
My lord, suppose there are 100 vacancies. 140 candidates are required to be called for interview. So, my lord, we all participated. We did not come for within those 140 according to the ratio. So, my lord, we are not called for interview. A panel, those candidates who fall under those 140, my lord, were called for interview. These, my lord, applicants were also within those 140. A panel was prepared. The panel was given effect to, and the panel expired in 2019, December 2019.
So you were not called for interview since in the written test you did not.
No, there is no, my lord.
Oh, what is the procedure?
That is, my lord, if there are 100 vacancies, 140 candidates are to be called in. That means in the ratio of 1:1.4. 1.4.
Hmm.
So I was not, there is a, suppose, my lord, 10 is
As per the vacancies, you did not come within that.
within this. So, my lord,
Now, what is the procedure? Then there is a written test. This panel, this one for 100, 140 candidates are called. These are the 140 means the persons who applied.
applied.
Oh,
And
there is
sort
no
of the
screening.
basis of academics and everything, thereafter the final merit list.
No, there is no screening for calling in the interview. 7 except 1 is to 1.4. No, that is not the view.
My lord, probably that manner of selection, rule 7, my lord, I am reading.
Yes.
Selection to the post of teacher except physical and work, this is not. My lord, thereafter, manner of selection. Selection to the post of teacher except physical education and work education shall be made category wise on the basis of merit weightage of TET, academic and qualification and marks obtained in personality test in the manner specified in part A of schedule 3.
Personally test. So you appeared in the person.
No. Personality test is thereafter. My lord, personality test is thereafter. My lord, thereafter rule sub-rule 2. Selection to the post of teacher in physical education and work education shall be made on the basis of the result of the written examination. In the written examination conducted by the Central Commission. Evaluation of academic score.
There you participated in the written test. Then you did not come within the zone of 1:4.
Yes.
So you are not called.
I was not called. So, my lord, written examination, not only written examination, after written examination,
Evaluation
evaluation of academic score.
Yes.
So, my lord, suppose evaluation of academic score and written examination, I got 40. Let us take a case. But on 1:4 consideration, the cutoff was 45. So, I did not come within, I was not called for the personality test.
So you are unsuccessful.
Here, my lord, on based of that, my lord, a panel was prepared. A panel was prepared, a waiting list was prepared. The panel was exhausted. All appointments were given, vacancies were exhausted. There was no vacancies. And the panel expired on 19th of December 2019. And my lord, the rule says under no circumstances the panel cannot be extended. The rule says. Thereafter, my lord, in 2022, suddenly the state or the commission framed this, my lord, 19th May 2022, creating supernumerary post. If these are new vacancies, my lord, then Rule 8 mandate that you have to call the candidates in the ratio of 1:1.4 because these are not vacancies of the that selection process. By creating 19th May 2022, my lord, the state has created new vacancies and there our right has been infringed because by whenever you are creating new vacancies, chance has to be given to everybody. That is violation of Article 14 and 16. There we are violated, my lord. We came before this honorable court saying that first you publish our Weimar sheet, publish the panel, and if you are to create these new vacancies, you have to follow the mandate of Rule 8. Now, my lord, for your lordship's consideration, may I read Rule 8? My lord, Rule 8. Information regarding vacancies. কোন ভলিউমে আছে এটা?
Very good. Rule 8. All right. Any other
My
argument?
lord, may I place Rule 8?
You have said, we have taken down.
My lord,
You have said that if it is a new vacancy, you have to follow the procedure in Rule 8.
otherwise it is a violation of Article 14 and 16.
Right, we understood. Any
Thereafter-
other argument?
Yes, my lord. My lord, Rule 15, my lord, says validity of the panel. Why I am saying placing this, my lord? Rule 16, validity of the panel. My lord, each panel and waiting list, my lord, that is very important. Each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or date of advertisement of the next recruitment process, whichever is earlier. My lord, no recruitment process has been initiated after this recruitment, this 2016. So, my lord, validity of the panel is 1 year from the date of publication of the panel. Next, notwithstanding, provided that name of candidates shall not be recommended against any post other than the post applied against any vacancy which has not been notified in terms of sub-rule 3B of Rule 8.
That is Rule
8.
No. What is the substantive rule?
So substantive
16.
rule is, my lord, West Bengal,
No. Rule 16 or
Rule 16. Validity of panel. My lord, now, my lord, Rule 19. Yes, my lord. Rule 19, my lord, says carry forward of the vacancies. If any vacancies remain,
all right. So your contention is that this was the actual contention of yours.
yes.
That there has been a deprivation since these rules have not been followed and supernumerary post, if at all created, that ought to have been created in consonance with the act.
In
Very good.
consonance with the act, giving us also
An
that
opportunity to participate.
And my lord, my fundamental point is, my lord, any recruitment has to govern by its rules. It cannot go beyond the rules. My lord, the rule says a panel
That is an argument on merit.
My lord, no, my lord, the maintainability, for going into the issue of maintainability, my lord, on facts, it is required, my lord, how am I aggrieved and what injury it has been caused to me. My lord, if after we are, everybody is saying we are unsuccessful. After the panel has expired, our status and their
Their
status
status is same.
is same. My lord, I grateful to your lord. So we stand on the same footing. So the question that we are unsuccessful, we cannot file the writ petition is not at all tenable, my lord, because where we stand now and where they stand, we stand on the same footing, my lord. And my lord, this when on the face of the constitutional court, a point has been raised that there is corruption and there is violation of rules. My lord, if your lordship goes to the impugned order, my lord, Supreme Court on n number of occasions from 1996, from 2025, Supreme Court has said not a single appointment can be given after expiry of pen. It can waiting list cannot be treated as a reservoir. এটা কোন judgment? My lord, I am reading paragraph 27 of the impugnment, and your lordship did not have to find. I'm just reading, my lord, from paragraph 27. The petitioners are alleging that has been created in the name of supernumerary post. As such, all participants in the said relevant selection test have a right to be considered against those vacancies. The allegations need to be investigated on merit, and without such step being taken, the writ petition cannot be dismissed on the ground that the petitioners being unsuccessful in the relevant selection test have no locus standi to maintain the writ petition. My lord, another thing, let us take, my lord, for argument's sake, the honorable division bench, though I am saying that not the applicant stated, the honorable division bench has stated, you heard the point of maintainability first, and the, my lord, single bench declined to hear it. My lord, they argued on merit. They have not challenging that the single bench will not hear the maintainability first. They will hear it together. They argued on merit. Now, my lord, they are stopped and cannot come before your lordship and say the maintainability issue was not taken up. My lord, it is not the fact. Please.
Today you have adopted a resolution.
Milord, I was appearing for the state.
Ah.
But I'm sorry, Milord, I could not respond when your lordships were inquiring about me.
Yeah.
No,
But would you,
again adjournment will be taken.
no. I'm here to, Milord, argue the matter.
But at a very
But give me, Milord, on the locus point, give me 5 minutes on the next day. Or I can finish it today itself.
Locus, you both the issue, two issues, the interim order in total entirety has been challenged before us.
Right.
So we cannot say that the challenge appeal in respect of one issue is accepted.
No,
And-
certainly not. Certainly not.
So we have to give answer, judicial answer to the query raised by the appellant in respect of both the issues.
Right.
Hmm.
And in fact, Milord, your lordship would also find, just Milord, not to Milord conclude things today, that way they were,
just one second.
I'm sorry, Milord.
We preliminary heard regarding maintainability issue and what is the issue, other issue.
Yes, Milord.
So
Okay.
this has to
Appellant
be
will
gone
be
in.
invited to make their deliberation on the both the issues.
The Supreme Court order,
Sorry.
Bhattacharya, where, Lord, the Supreme Court did not keep the question of creation of the supernumerary post open. This is one fact which must be brought to your lordship's notice. Lord, in the additional,
So for that we have to go into the merits, Mr.
Yes,
Gupta.
yes. Your Lordship would hear us, my lord, on this.
But
Your
if
Lordship
you
would definitely hear us on this.
not argue any other point,
No, no.
but you decide the maintenance, then it becomes difficult for
My
us.
lord is of the view that my lord will hear out the entire.
Prima facie, it appears that we must go into it. If you want us that then you pass an order to that effect, we will test it in Supreme Court. That is another aspect of the
No,
matter.
in this way.
In this way, Mr. Kaur, how can we proceed? So we would request Mr. Sengupta, we have heard you on the point of merit, the argue on merits and finish it up. We will finish it up. Yes, Mr. Sengupta, you have any problem to that?
But I think Mr. Shengupta is not online.
Yes, yes,
Yes.
very much.
So you are online, you are offline. You don't
And no, Mr. Advocate General was of the understanding.
No, no,
Since there is
I'm
a
sorry,
rising
my
at court at 3:30, Mr. Sengupta has left as usual.
take it up with him in other fora. So, Mr. Sengupta, we are desirous of hearing you on merits of the matter. You have argued on the maintainability point. You say when you are arguing on merit, we will decide it. Yes. Chalo.
My lord, only one humble request before your lordships, my lord.
Next day.
Only thing, in this way, allow your senior to say,
My lord,
We are, sir, inviting, we have told Mr. God. Prima facie, we think that it has to be gone. Now, if after this, if we invite your senior, he has to return his argument on that, then now we can decide. Or you can say that no. First you answer whether it is
it
made.
cannot be.
my lord, only
In respect of
my lord,
one matter, five judgment
your
cannot be.
lordship has
On
rightly
the issue of first issue,
my
one
lord,
judgment,
pointed out
second
that
issue, another
that
judgment.
issue has to be gone into, my lord. I believe Mr. Shengupta, my lord, senior Mr. Court, the state, my lord, our chance after, my lord, 4th May, they will also take some time, my lord, since I am being led by Mr. Murray, our after 4th May. In the meantime, your lordship can fix any date, they can complete. This is only one.
Sir, we have other matters also.
My lord, my lord, I understand, my lord, your lordship kindly consider, my lord, our previous.
It will go in May. It will go in.
It will go in May.
Ashok, we have.
appear on behalf of the respondent number 3.
Yes, yes, give-
We have
Ultimately, your lordships are going to merit.
yes, Mr.
Yes,
Singh.
both the
Yeah,
issue.
both the
Both
you
the
have argued on maintainability. We are fixing a date. You argue on the main matter. We will finish off the case.
And Mr. Dasgupta will say, if it goes to Haram, since Mr. Sengupta argued on merits also, they are stopped from questioning that.
I've said, if we find that the petition is not maintainable, there is no question of going into the next.
Yes.
Find this maintainable, then the question of determination of next issue will come.
We
My
have,
lord, we will address your lordship, my lord, on the merits without prejudice to our point of locus.
Yes.
We'll make those submissions.
we have extensively heard Mr. Sengupta and Mr. Sengupta, learned advocate, the senior advocate appearing for the appellants in MAT
MAT
2171 of 2025. As also and also Mr. Kaur, learned senior advocate appearing for the appellants in FMA 74 of 2026. Mr. Mr. Dasgupta, learned advocate. However, Mr. Sengupta extensively heard. However, due to paucity of time, the learned advocates appearing for the state and the respondents. We have extensive have not been able to conclude their arguments. In view thereof, leaves the matter for further consideration. the daily supplementary list of these two, I didn't get. 11th এর আর কোন date? On 11th May as fixed at 2 p.m.
DP of that. সব বছর
ইয়ে কোনটা?
For addition of party, my lord. Well, 4 matters were hard together and analogously, and judgment was passed in all the 4 matters, my lord.
It does all that. Clear.
কোথায় আছে 5:30টায়?
Deeply open.
তো ইয়ে